I'd like to thank everybody for joining us today for the webinar. Today's presentation is on Iowa Adjudication in dealing with the child need of assistance. You will see that you have a chat box option that you can ask questions during the presentation, and we'll take those questions at the end. So feel free to type those in at any time. I'm going to do a sound check, so if everybody could just raise their hand if they can hear me just fine, that would be great. You can click the little hand. Thank you. Today's activity ID number for today's program is 150682. That number again is 150682, and I will also repeat it at the end of the webinar for you. I'd like to introduce our today's speaker. Jenkins-Antonuccio graduated from the University of Iowa in 2008. She currently practices law in Juvenile Division of the Iowa City Public Defender's Office. Prior to accepting her current position, Rachel spent 4 years in private practice focusing on criminal defense, juvenile law, family law, and appellate work. Rachel, I'll turn it over to you now.
Thanks, Christy. Can you hear me okay?
Yes, I can hear you good. Thank you.
Okay, great. Sounds good. If you can at any time, feel free to just let me know, and I'll have my cell phone out too, Christy, if you need to give me a call. Thanks for the introduction. As Christy said, my name is Rachel Antonuccio. I'm an attorney in the Juvenile Division of the Iowa City Public Defender's Office. My job is exclusively, well, almost exclusively, I've done a little criminal work, but for the most part, I'm representing parents in child in need of assistance actions now. So I've been here for about 1.5 years, probably had 100 cases in that time. In my 4 years in private practice, I probably had another 100. So I've had a fair number of experience with this, but I am always learning more, and I by no means know everything. I'm guessing there are plenty of you in the audience who have just as much experience, if not more, than I do. So please, when you're asking questions at the end of the session or throughout the presentation, feel free to supplement anything that you've had different experiences with or anything that you think should be handled differently or better. That's just as important to me as any information that I might be able to relay today. So thanks for giving me the opportunity to do this. Just to get started, I should first credit Judge Alan Albee's Juvenile Bench book. If you're an attorney doing any kind of child in need of assistance work, make sure that you have access to that. You can actually get a lot of the bench book online. Drake University has large portions, maybe the whole thing, online as a resource, and I reference that book every single week. Judge Albee has forms for everything. He has case law citing every code section there is in the juvenile code section. So I think that's a wonderful resource, and I'd encourage you to check it out if you're doing any child in need of assistance work. And I referenced his bench book a lot when I was preparing this presentation, so I need to give him a lot of credit. I'll start first with some statutory definitions for children in need of assistance. First of all, child means a person under 18 years of age. I actually had a case come up just yesterday where we were wondering if we could actually extend the child in need of assistance action past the child's 18th birthday because he's in residential care that will need to continue past his 18th birthday and would not be able to move into his adult placement until basically a month after his 18th birthday. And I spoke with 2 judges and with the Johnson County attorney, and there's really no wiggle room in that area. Child is a kid under the age of 18 who is unmarried. And specifically, the child needs to be unmarried at the time of the adjudication. So at the time the court finds the child to be a child in need of assistance, the child needs to be unmarried. If the child marries afterwards and is already adjudicated, it's too late. So that is that. A parent, which will come up a lot, obviously, in child in need of assistance actions, is a biological or adoptive mother or father of a child, but that does not include a mother or father whose parental rights have been terminated. I've had several of both, biological and adoptive parents, and they're both defined as parents in the code. A guardian is a person who's not the parent of a child, but who has been appointed by a court or juvenile court having jurisdiction over the child to make important decisions which have a permanent effect on the life and development of that child and to promote the general welfare of that child. A lot of times you'll see this as a family member, grandmother, aunt, something like that, who has kind of intervened when this kid has had issues and the court's made a decision that this person's actually a guardian. Custodian, a step-parent or relative within the 4th degree of consanguinity to a child who has assumed responsibility for that child, or a person appointed by a court or juvenile court having jurisdiction over a child. So that's pretty self-explanatory. Except for good cause shown, or unless the child is returned to the place where the child was residing, the petitioner needs to file the child in need of assistance petition within 3 days of an order removing the child from that child's parent, guardian, or custodian. So that's just important to keep on top of. As a parent's attorney, I don't always get appointed to the case right after the removal or prior to the removal. But if you do, in fact, get appointed prior to the removal, just keep close track of that deadline. It's something that you may be able to use to assist your client if the petitioner is not filing on time. The people who can file a CINA petition are the Department of Human Services, a juvenile court officer, and the county attorney. And typically in Johnson County, which is where I practice in Iowa City, I don't think I've ever seen anyone but the county attorney file the petition. The department usually provides a supplemental affidavit, but typically here the county attorney takes care of that. So the court has to make a preliminary determination about whether, if proven, the facts in the petition constitute grounds for adjudication. So first of all, the court's looking at the petition to make sure that it includes everything that the petition is required to include. And if you want details about that, you can look in Iowa Code Section 232.87 and 232.36, which just outlines the technical requirements. I think of the petition as a trial information in a criminal case. So basically the state or whoever the petitioner is outlining, in my mind, their ideal case because they want to get past that preliminary hurdle. So you're going to see a lot of bad facts in there, a lot of one-sided language, but that's what's going to the judge to get initial approval to proceed with the child in need of assistance action. The rules require that once the petition is approved, the adjudication hearing has to be held within 60 days of the filing of the petition unless good cause is shown. But the case law is really has a lot of wiggle room there. So for example, in the interest of NMW, and the site for that is 461 Northwest 2nd, 478. This is an Iowa Appeals Court case from 1990. A parent asked to have the action dismissed because the hearing was not held until 105 days after the petition was approved. And the court said, no, you can't show that there was any prejudice to you by the fact that it took so long for us to hold this hearing, and you waited too long to bring the issue to the court, so we're not going to dismiss the action based on that. I mean, and the rules of juvenile procedure support that. The failure to comply doesn't result in automatic dismissal of the action. I've not yet had a case where that's come up, but it looks like if it comes up, it could be tricky to jump that hurdle, but it's something that you should certainly raise if the state's not getting the hearing set or if the court's not getting the hearing set in a timely way. So when the court sets the hearing, this is in Johnson County, and I'm assuming it's in other counties, certainly in Lynn County where I've done a little work, this is how it worked as well. The court sets what's called a pre-hearing conference, and that's usually set in for about 30 minutes. At that time, the court can take a stipulation if the parties are in agreement and ready to stipulate that the child is in need of assistance, or the parties can use that time to request a trial. And usually if I'm in a situation where we're requesting a trial, the court has us use that time to fill out sort of the pre-hearing information, so to list our witnesses and to list our exhibits and kind of set final pre-trial deadlines to make sure that everyone still wants to go to trial, all of those things. I have occasionally seen the court make the parties start the trial right at that pretrial hearing, which has always been unexpected, or at least I guess I've seen that a couple times. has been unexpected and can kind of make you scramble. So it may be wise, if you're not planning on stipulating to adjudication and planning to ask for a trial, to kind of check out the court schedule, make sure that there's nothing that's going to allow the court to kind of make you start your trial right away, or get in touch with the county attorney and kind of plan that out ahead of time, get your witnesses stacked up, get things ready to go, just in case. I think it's fairly rare, but I have seen it happen, so it's just something I try to be cautious of when I'm going to these adjudication pretrials. When the petition is filed, the court appoints an attorney and guardian ad litem for the child. And so typically the same person is appointed to serve both roles. In Johnson County here, the Lynn County Advocate is always appointed as the attorney and guardian ad litem for the child. And if they have a conflict, then that case can go to a private attorney, but that's kind of the first line there. Obviously, the attorney and guardian ad litem can have two different roles. So the attorney is supposed to advocate for the child's desires and intentions if the child can articulate that position and is old enough and articulate enough and capable enough to do that. The guardian ad litem is advocating for the best interest of the child. And sometimes the child's position, what the child wants to happen, and what the guardian ad litem thinks should happen are two very different things. So the State Public Defender's Office hosted a conference in the middle of June, and we had Brent Pattison from the Drake Legal Clinic, who deals a lot with child in need of assistance case as a guardian ad litem, talk to us a little bit about the ethics involved in these child in need of assistance cases. And if you're appointed as a guardian ad litem, or if you're a parent's attorney kind of thinking about these things, it's wise to ask if these roles should be bifurcated. So, for example, I have a case right now where the kid is 16, the kid would like to be home with a parent or making moves towards going home with a parent. The guardian ad litem doesn't think that's maybe in the kid's best interest. So is it time to maybe bifurcate that role and get someone new to actually serve as the attorney and advocate for what the kid wants, which is to go to a parent? Or does it make sense to kind of keep both roles with the same person? My office has before, and this is my predecessor, I did not personally do this, in a situation filed a request that the court order the roles be bifurcated. And I think ultimately the parties agreed that the roles should be bifurcated, so there wasn't a hearing on it. But as a parent's attorney, it's something to think about if you know that every time you talk to your client, they're saying my kid wants to come home, the provider reports are saying the kid wants to come home, and yet in court the attorney's arguing that the kid should stay in foster care or in some other placement. It's just something to think about and maybe raise with the court if you're having concerns that the child's voice is not actually being heard in terms of that child's own desires and wishes. Another issue that Brent Pattison brought up that I had not thought about before, but which makes sense, is whether different kids in the same family should have different attorneys and guardian ad litems. Typically in Johnson County, and again I'd be interested to know if this is how other counties always do it, just one person is appointed to all the kids. And so, for example, I had a client who had 6 kids, and those kids ranged from infant to 13, 14-year-olds. The infant is going to be in a way different position than the 13 and 14-year-old. So Brent Pattison encouraged, again, guardian ad litems to be thinking about, is this something where I can serve this role ethically for all my clients, or do I kind of need to talk to the court about switching things up, maybe getting different attorneys and guardian ad litems for different kids, or bifurcating my role so that I'm just GAL for these kids and they actually have an attorney of their own. So just ethical issues to consider at the outset of a case. The guardian ad litem has several statutory mandated duties pursuant to 232.2 sub 22. And obviously if you're guardian ad litem, it's very important that you're very familiar with these duties so that you're making sure you're fulfilling your role. But as parent's attorney, I think it's equally important to be very familiar with the guardian ad litem's duties, because you want to make sure that you're holding the guardian ad litem to task, that you're kind of keeping that person's feet to the fire. because that person can often be the key to getting your client's kids back home. So the first duty of the guardian ad litem is to conduct in-person interviews with the child and interviewing each parent, guardian, or other person having custody of the child if authorized by counsel. The if authorized by counsel part is huge. There are certain clients that I feel totally comfortable with them speaking to the guardian ad litem. There are other clients that I don't want anywhere near the guardian ad litem for fear of what they're going to say or what's going to happen or how things could get twisted. So it's important to make very clear to the guardian ad litem your position. I don't want you interviewing my client without me there, or nope, that's fine. In my experience, guardian ad litems won't always ask, so it really, the onus is on you as a parent's attorney to make those things clear. Guardian ad litems also won't always pursue meetings with parents. Sometimes the entire perspective of the guardian ad litem is based on the petition or what the foster parent has said or what they're hearing from the social worker, and the parents may have extremely valuable information that if the guardian ad litem had, or even their personality, if the guardian ad litem could see what your client is like, really making that person human to the guardian ad litem may change the guardian ad litem's perspective. So make sure that you're keeping on top of whether guardian ad litems are keeping in touch with your parents and making sure that the guardian ad litem knows your position. I think it would be helpful to say so in writing about whether they can interview your client without you present. I've also had experiences where the guardian ad litem has not interviewed the child prior to court-ordered hearings. That's also part of the statutorily mandated duties. So it's important to make sure that the guardian ad litem does that, and if the guardian ad litem hasn't, to maybe raise that with the court, which obviously can be awkward and uncomfortable, but given that that's one of the mandated duties, it's important that those things are happening. You can see I've kind of listed the other mandated duties there, and I think those are pretty self-explanatory, but as a parent's attorney or a guardian ad litem, it's just important to keep up on those things and making sure that they're happening. As a parent's attorney, maybe supplementing information that you don't think the guardian ad litem has seen or that you think is otherwise relevant to make sure that the guardian ad litem's recommendations are really in the best interest of the child and with full knowledge of what's going on with the child. Okay, so again, parents, fortunately in Iowa, have the right to counsel in child in need of assistance proceedings. And indigent parents and guardians and custodians can apply for court-appointed counsel, which is probably how most of us end up appointing parents. An important thing to know is that indigent folks are required to repay the cost of representation for their attorney. And it's important your clients know that up front because that can be a huge cost to people. Another important aspect of this is State v. Dudley, which is a case that came down fairly recently. Forgive me, I don't have the site in front of me. But it has a lot of takeaway lessons, but one of which being that attorneys need to be advocating that our indigent clients are not able to pay our court-appointed attorney's fees. Of course, you're still going to be billing as you normally would, very honestly with the state public defender, listing all your time that you've spent and making a clear record about that because you need to get paid on your end. But in court, it's important to bring to the judge that your client just truly cannot pay. Provide some evidence of that, some financial affidavits, maybe request an in-court hearing. I will say I've heard horror stories. I participated in a webinar a couple weeks ago regarding the Dudley case and just regarding basically the cost of being indigent and involved in the court system. And I think in certain counties, the judges have not been really helpful in limiting indigent people's bills. In Johnson County, I have to say, our district associate judges have been wonderful. If you are advocating for your client and indicating that they're not able to pay, then they've really listened to that, and I think most of my clients have been able to get away from their case without paying much, if anything. If anyone wants, Professor Emily Hughes, she's a University of Iowa law school professor, she did a really excellent PowerPoint on the Dudley case that I think would be worth looking at if that's an area of interest to you. And I can get access to that if anyone would like to take a look at that. The findings in that case are a lot more nuanced than I've presented here, and I think as people advocating for indigent folks, it's just good to brush up on that case and make sure you're doing everything you can for your indigent clients. Okay, so after the petition is filed, the court shall issue and serve summons, subpoenas, and other process as provided in Section 232.37. The summons and notice are different. Persons summoned to a hearing are required to attend. They should be served personally by the sheriff. That service should have a copy of the CINA petition attached, and the service needs to be made 5 days before the time scheduled for the hearing. Now, this is important especially important if your client's children have not been removed from their care, because if your client is properly summoned and fails to appear without reasonable cause, your client can be cited for contempt, the adult can be arrested, and the child can be taken into custody. So I had a case where the beginning of it seemed ridiculous, but it got out of hand quickly. The petition was based on the fact that the children had not been to the dentist, and apparently were experiencing some tooth pain. And that's important. Obviously, those kids needed to get to the dentist. The department had elected not to remove because it seemed like an issue that was easily fixable. And so the adjudication hearing was set. In the interim time, and I've only had this happen this one time, the parents fled with the kids and took them to Illinois. And so, again, because they were summoned, they were required to attend, and warrants were issued for their arrest. Ultimately, the case ended up closing. They got services in Illinois. It was fine. But it certainly gave me a little bit of a panic attack and made me realize that it's especially important that when people have their kids, they know that their attendance is mandatory. People given notice of the hearing are permitted to attend, but not required to do so. And failure to attend for those folks does not result in contempt or arrest. So I have parents who are given notice because they don't have custody of the kids. I still, just as best practices, I know that they don't have to be there. I know that they're not going to be arrested if they don't come. But if I have a parent, for example, who has a work schedule and cannot get out of that to attend a hearing, I try to file a motion with the court requesting that their presence be excused. And I think that kind of helps twofold. I think it makes the parent feel a little bit better, and it also shows the court that the parent is interested and involved, but maybe has a blockade making it difficult for them to actually attend. So I just think that's best practice if you're able to do that in advance of a hearing. Okay, so unless all parties waive reporting, all adjudicatory and other hearings in a child in need of assistance case have to be reported either by a court reporter or tape recorded. And child's counsel, not the child, can waive the requirement on the child's behalf. We don't have this in Johnson County yet, but apparently in 2009, the Iowa courts started using digital tape recording, and that's an acceptable way of reporting those hearings. We still are using court reporters in Johnson County, which I think is preferable, but I know with budget issues that's not always possible. One thing that it's important to remember for your clients who do not speak English, if the hearing is interpreted by an interpreter, the non-English testimony must be tape recorded. And actually, when I was preparing for this, I realized just the other day that the court had not tape recorded the testimony of a non-English client. So that's something that, as attorneys, it's wise to be on top of, and just making sure that if that's an issue that's coming up in your case, that the court's getting a tape recorder out and getting that part of the code fulfilled. Okay, so talking about CINA hearings generally, I think a lot of people think that because CINA hearings involve kids, they're confidential and not open to the public, and that's not the case. Adjudicatory hearings are open to the public unless the court, upon its own motion or upon the motion of one of the parties, closes the hearing. And in order to close the hearing, the court has to find that the possibility of damage or harm to the child outweighs the public interest in an open hearing. So if you're a parent's attorney or a guardian ad litem and you're thinking about this and concerned about how that's going to affect the child at issue or the whatever your concern is going to come from having a public hearing, I think best practice would be to file a motion or request a hearing on that issue beforehand. It may just give the court a little bit more time to evaluate your request rather than the court having to make that decision right when you walk into the room ready to go with something substantive. So that would just be my suggestion if that seems like something that's going to be an issue. I don't think I've had it come up yet where I felt certain that it would be very harmful for a client, but I could certainly see that, especially in the guardian ad litem role. So just something to think about. Okay, so burden of proof. Obviously, the petitioner bears the burden of proving the allegations that the child is a child in need of assistance, and that standard is clear and convincing evidence. So that standard is obviously more rigorous than the preponderance standard, more likely than not, but less rigorous, obviously, than beyond a reasonable doubt. So basically, the petitioner is having to prove that the allegations are substantially more likely true than not. I will say, and again, I'd be interested in other people's perspective on this, given that the court is really evaluating the best interest of the child, I think the court's understandably a little nervous about making a mistake in terms of not adjudicating a child. I often feel that clear and convincing is not the true standard. Preponderance is more of the standard that I'm operating with. But again, I'm sure that varies judge to judge, county to county. But it's just something to be cognizant of when you're thinking about going to trial and when you're reviewing the case with your client, just being realistic about what the code standard is versus how things may work in reality. The second part, the petitioner doesn't just have to prove that the child's a child in need of assistance. The court also has to find that its aid is required. So it's not just enough to be a child in need of assistance. So again, the court's going to think about that really carefully because the court wants to do what's right for these kids. So in the interest of GR, which is 348 Northwest 2nd, 627, the court said dismissal is really proper on this ground in only 3 situations. When the juvenile court doesn't have treatment or service available to correct the child's particular problem, when an alternative system of services is available to provide comparable treatment without the court, or when resources are available to the court to correct the children's problems, but experts predict little likelihood of success without extensive cooperation from the parents and the child, and that cooperation is not forthcoming. So those are fairly limited circumstances, it seems, when the court would dismiss because it didn't find its aid is required. I have made this argument at a dispositional hearing, and actually one fairly recently, and the court agreed. I mean, at that point, the case had been open for a little while. We had stipulated to adjudication, but done sort of an ALFORD stipulation, which I'll talk about later. The parents had successfully done everything that was asked of them, and frankly, they were kind of tired of working with DHS, and we were a little bit concerned about whether they would be as cooperative going forward. And we said to the court that we think, the services have been provided that could be provided. We don't think there's much more to do, and frankly, even if you ask the parents to do something, at this point, they're frustrated because they've done everything that's been asked of them. We're not really sure where else this can go. And the court agreed in that case and agreed to dismiss the action at the dispositional hearing. So you may have more success with that later down the line than you will right at adjudication because the court wants to kind of err on the side of caution, it seems. Okay. So in the vast majority of adjudications, you're not going to go to trial. So I spend a lot of time strategizing about ways to have a successful case without an adjudication trial because a lot of times the parents want to stipulate or the allegations are fairly severe and are provable. What I've been working on a lot in less severe cases and where the parents have been really cooperative, so I've been having some good success with, is trying to convince the petitioner to hold the case in abeyance. So basically, the petition's been filed, the hearing's been set, and you ask if your client continues to do as well as they've been doing and things are safe, if maybe we could just set that adjudication hearing back out a little further, see how things go, and then dismiss at the time of the adjudication hearing if things are going well. And if you have clients who are really compliant and getting things done, and if the infraction is, fairly small in terms of the whole range of things that a child can be found or adjudicated for, that's something that may be able to work for you. One of those things is you'll probably have to waive the 60-day time frame in order to work through those terms and conditions that the department might set to hold the case in abeyance. So just being conscious of that and maybe taking care of that in advance to give yourself a little wiggle room. And if parents can do well, then I've actually had several cases where we've dismissed at the time of the adjudication hearing without actually the child being adjudicated, which is great if that's a safe and healthy resolution. Okay, so stipulating to adjudication is a situation you'll probably find yourself in the most. As parents' attorneys, always make sure you're talking with your client's criminal counsel if your client has criminal charges stemming from the issue on which the CINA petition was filed. So I'm lucky because I work in the public defender's office. Most of my clients' attorneys are in the office next door to me. But wherever they are, it's really important to keep in close contact because obviously things that your clients say in the CINA case and stipulations they make could come back to hurt them in a criminal case. And obviously the repercussions are very different in both situations. I also try to always keep the stipulation as narrow and limited as possible, which means I pay really close attention to the grounds that the state has alleged in its petition. So you'll find the grounds in 232.2 sub 6. An example I would give you, I had a client who some drugs were found in the basement of her house where her adult son was living. She lived on the top level, he lived on the bottom level. They kind of never met in the middle, but there was a big drug bust and they found a bunch of drugs downstairs and a CINA was filed because she had a younger son who was also in the house. So the state pretty much threw every code section into the petition that had anything related to drugs. But when you kind of broke it down, there was really nothing backing up most of those code sections. So there was no evidence that my client was using. We made sure to get her a hair stat and had her do a UA straight away so that we could prove that. There was some allegation that maybe the adult son was producing amphetamine, but first of all, there was actually no amphetamine found when everything shook out, and we weren't sure that the state could prove that if there were amphetamine found that my client had any knowledge about it or knowledge of its manufacturer. So just keeping close attention to that, we got those grounds dismissed from the petition straight away. Just keeping good track of that is really important because the county attorney is going to add everything they can in their petition so they can pass that preliminary hump and get things moving forward. So you've got to be a really good advocate for your clients and make sure that the county attorney can actually back up the allegations and the grounds in the petition. Okay. Another tool I rely on a lot, if there's a name for this that someone knows of, please let me know. I always call it the ALFORD stipulation, basically the CINA version of an ALFORD plea, but there's probably a real title for it that I'm just not aware of. So basically, when my clients have any criminal charges pending, I enter into a stipulation indicating that we do not admit the allegations in the petition, but rather we acknowledge if the matter proceeded to trial, the child would likely be adjudicated a child in need of assistance under whatever grounds we've agreed to. I think in these situations, a written stipulation is the best practice, and I often specify, for example, that we believe the state could win a trial because, for example, I have advised my client not to testify because they have pending criminal charges, or their criminal attorney has told them not to testify. just to be clear about that so that the court has an understanding of why you're stipulating. I think the written stipulation is also good for two other reasons. First, if there's an abuse reported issue that you're appealing, you can enter your written ALFORD stipulation as an exhibit. And I think that does a good job of making clear that your client has not admitted the allegations at issue. It also, I think, just makes your clients feel better. The court usually enters an order that just says everyone's stipulated to adjudication, but they don't provide context for that stipulation. And that can be a little jarring for your client who says, but wait, I thought we did it this way, and feels that they've sort of been slighted. I've in the past filed 1.904 sub 2 motions to amend findings when the court orders haven't reflected that my client's stipulation was an ALFORD stipulation, and those have been denied. So I don't mess with it anymore. I just do a written stipulation that clarifies how we are not stipulating. I think that kind of makes the record more clear, and it makes your client feel better, and it's just kind of a win-win for everyone. Okay, so I did this for the first time recently, and again, I'd be interested in what people think, if this is a good or bad move. Because the facts in the petition are so one-sided and sometimes very inaccurate, our clients often have a really hard time with what's being alleged and really want to clear up the record. And there are sometimes when that's a good idea to give them a chance to do that, and there are other times when it's not going to be helpful or could be harmful. I had a case where there was a sexual assault between siblings in my client's home. The issue was some mental anguish that the child had endured because initially no one had believed her claims about the assault. The petition said that my client failed to cooperate with DHS and law enforcement and repeatedly thwarted investigative efforts. Well, what my client had done was go talk to an attorney and say, what should I do? And that attorney said, don't talk to anyone, as any good attorney would. So it was really a situation where we knew this kid was going to be adjudicated given what had transpired and kind of the issues that she had endured. But the facts were so skewed that my client really wanted to get something on file that would explain his version of events. So we did. We just did a filing that said we're stipulating, we're not admitting the allegations in the petition, and we're clarifying in these various ways. In this case, he had no pending criminal charges. There was no abuse report, so I felt a little more comfortable with that, and I clarified that with the county attorney and DHS many times before we filed it. But, you know, it's one of those things that maybe could come back to bite you and your client later, because it is a written record of your client's version of the facts, and who knows how that could come back later. You know, I filed it from my perspective. I did not file it as an affidavit from him. So if later it turned out that I had made a mistake or gotten something confused, I was hopeful that that would not come back to hurt him, but rather that could be an error on my part. So I guess it's just thinking seriously about if that makes sense. And again, I'm sure there are people who would think that's a terrible idea and would never do it, but I'd be interested in other people's perspectives. Okay, so taking it to trial. I always talk really carefully with my clients who want to go to trial about the risks and benefits. The thing that I'm most concerned about, because I've seen it a couple times in Johnson County, are removals after the fact from clients whose kids initially were staying with them, but were not cooperative in adjudication proceedings, and the court found that it was appropriate to remove the child from their care. Again, I've only seen it a couple times. Fortunately, in both cases, I was not representing the custodial parent, but it was really shocking and really terrible for the parent involved to have their child removed from them suddenly just by the court without any request from DHS or any of the parties because they weren't being cooperative. So I think that kind of sticks in my mind, and I do tell clients I've seen that a couple times. You know, I'm not saying that's what's going to happen here. I'm not saying it's right or fair, but I'm just saying it's something that could happen. We have a county attorney in Johnson County who used to be a prosecutor, and at one of her CLEs, she said that when she was county attorney, she really liked it, when parents wanted to take their adjudication to trial, because it really gave her a chance to dig up all the bad facts that weren't previously on the record, create some issues about, whether the client was going to testify or not, and kind of imprinting the case on the judge's brain. So if things are a quick stipulation and you move on, the court probably doesn't think too much about that case. But if the judge spends 3 days in a contested trial with you, that's going to be something that they're thinking about seriously. If they decide to adjudicate, they have a lot more information and a lot more, probably at that point, more concerns than they did previously. So it could make for a rougher case down the line. That said, we want to hold the parties in the department to a high standard. And a lot of these reports have so many vague comments or so many findings that seem inappropriate. And there's obviously plenty of times where we think things are just flat out wrong or have been completely misunderstood. And we want to get that adjudication, we want to get the case dismissed, and we want no adjudication. So that's something that, a lot of clients have to weigh over very seriously. And it's important you try to help guide them through that as much as possible, being very honest about the risks, but also acknowledging that this is their kid and they're kind of the boss. And if they really decide, knowing all the risks, they want to go to trial, then there you are. So it can be tricky. Okay, if you do take it to trial, one of the things that can be really tough are the rules of evidence in these CINA adjudicatory hearings. So evidence admissible under the rules of evidence applicable in civil cases is also admissible in CINA adjudicatory hearings, except for there are a million exceptions that basically decimate the rule when all is said and done. The adjudication standard is still stricter than the dispositional standard, because in dispositional hearings, all relevant and material evidence is admissible. But in adjudication hearings, the case law makes it clear that the rules of procedure are to be liberally applied so that all probative evidence is admitted. And again, we're dealing with best interests of the child, so the court wants to be cautious. CINA cases are also equitable in nature, which means objections to testimony are ordinarily not ruled on, and all evidence can be received subject to objections, so the entire record may be available to the reviewing court on appeal. And again, it seems, in my experience, that most things are going to get in. The court's just going to err on the side of caution. Some of the exceptions, okay. So we have present sense impression, excited utterance, statements for purposes of diagnosis or treatment, recorded recollection, and records of regularly conducted activity. We also know that reports of child abuse get in. So those are the allegations made to the department, not the assessment report, although that also gets in. And you don't need the actual reporter to testify in order for the abuse report to get in. That can come in as hearsay through the child protective worker. And in fact, the actual reporter is protected, and their identity is to remain anonymous and shall not be revealed. So all that stuff's going to come in through hearsay. Traditionally, obviously, communication between husbands and wife is privileged, but not in CINA adjudicatory hearings, and in fact, not in any civil or criminal proceeding where injury to a child is involved. Again, normally we'd have privileged communication between patients and physicians, but no, not in a CINA adjudicatory hearing. And basically, the court has said patient's interest in proper diagnosis and treatment takes a backseat to the prevailing interest of proper care and treatment of a child in need of assistance action. Privileged information with a mental health professional is not protected anymore. And of course, regularly kept records will come in as well, unless they're inadmissible for some other reason other than the hearsay rule. The most important exception in my mind is the report or tape by DHS, peace officers, or hospitals. So there's exceptions for any report, study, record, or other writing, or an audio tape or videotape recording made by the Department of Human Services, juvenile court officer, a peace officer, or hospital relating to a child. So as long as that content is relevant and material, and its probative value outweighs the danger of unfair prejudice to the child's parent, guardian, or custodian, that stuff's coming in. And so basically, I mean, it's a dream for the state because their client is preparing the information that's guaranteed to get in. So it's a lot easier for them to make their case knowing that all of that hearsay is going to come in. So again, just a lot of stuff coming in that creates a lot of obstacles for your client. Without prior consent of the parties, the social history is not to be considered at adjudicatory hearings. But, you know, obviously the social history is formulated over time. So there are going to be pieces of what's in the social history sprinkled throughout your adjudication record. The Sixth Amendment right to confrontation of witnesses only applies to criminal cases, not child in need of assistance cases. So you can make some objections, especially if you've made reasonable efforts to obtain the presence of the maker of a report and have been unable to do so. But the court can still say, nope, that's coming in. One thing, the portion of the abuse report may be deemed inadmissible if it contains the results of a polygraph exam that the parties did not agree were admissible. So if you have a polygraph in your case, that's just something to be aware of. All kinds of evidence can get in, direct or circumstantial. Uncontradicted testimony cannot be totally disregarded by the court. The trier of fact, of course, is not bound to accept that it's true, but they can't totally disregard it. The credibility of witnesses is really just the same as the Iowa Civil Jury Instruction Standard. So the trier of fact is going to have the same abilities there as they would in a civil jury. They can believe all or none or part of the witness's testimony. They have to try to reconcile conflicts in the evidence, but the evidence found more believable should be accepted. And there are a number of factors they should consider when deciding what testimony to believe, and all of that's listed here. Again, opinion testimony and expert testimony, there's a lot of wiggle room there to get things in. So the rules of evidence permit lay witnesses to express opinions if those opinions are based on the witness's perception and provided that information is helpful to the determination of a fact and issue. So that stuff's probably coming in. The same with expert testimony. It's not admissible unless the witness is shown to be qualified and the facts upon which the expert bases his or her opinion are sufficient to enable a witness so qualified to express an opinion that's more than conjecture. But it's very liberally construed. So, for example, in the interest of Long, the court found that a registered nurse, a child and family therapist, child and adolescent psychiatrist, and the director of a pediatric residence program were all competent to give expert testimony regarding potential harm to the child given the mental and emotional condition of the child's mother. So they're evaluating the child's mother's issues and talking about how it could potentially harm a child, and all that stuff is coming in. The criminal rules apply in CINA Adjudications in terms of the following issues. So truthfulness of a child abuse victim. An expert witness can't testify that children that seldom testify falsely about these matters because that kind of invades the judge's province to determine the credibility of the witness. But experts can testify about verifying the truthfulness of sexual allegations and kind of explaining reasons for delay by some children in reporting sexual abuse. In terms of post-traumatic stress, if the expert does not offer an opinion on whether the person has actually been raped, they can admit some testimony regarding the effects of post-traumatic stress syndrome and the typical reaction of a rape victim. Experts can testify properly as to why sex abuse victims delay reporting a crime. They cannot testify about the typical sexual offender profile and how your client or defendant fits that profile. And all that case law is from criminal cases, but it's still applicable to child in need of assistance actions. All evidence must be relevant, but again, you know, it seems like in most cases, if there's any question, it's coming in. So the only thing that you can really rely on is that if something that's coming in is unfairly prejudicial to the adverse party, that may be a way to keep it out. But a lot of that stuff is just going to get in. We're getting to the end of the time, so I'm going to kind of try to flip through these things. A lot of these are just rules of evidence that you all will already be familiar with from any criminal work or from civil work. But prior bad acts, in terms of the judge's peculiar knowledge, the judge can rely on that knowledge, and but the judge cannot rely on knowledge outside of the trial and issue. That said, if the judge has gone to a conference, for example, and attended a medical seminar, for example, and received some knowledge from that, the judge can bring that in to his or her consideration when deciding whether to adjudicate a child. Children are presumed competent to testify, and additionally, a parent does not have a right to be in the room when their child is testifying if the court finds that that would be would hinder the child or make it difficult for the child to testify. Incarcerated parents have no absolute right to be present for these hearings. I try to file motions requesting that they can be present or appear by telephone. You know, our judges do it differently. One judge does never wants people from the jail coming over. Another judge is okay with people coming over from the jail sometimes, but it's just important to try to clarify those things in advance. Forgive me, I'm going to try to speed through this a little bit just so we have some time. So a predispositional order of adjudication is not a final order, so it's not appealable as a matter of right. So you're going to have to wait for the disposition if you're unhappy with what's happened in an adjudication order. And that makes some sense. I mean, some of these issues may be able to be resolved by the time the dispositional hearing comes around. Certainly if people are able to get their kids back successfully in between the adjudication and the disposition, or if kind of the tensions have calmed, your client may no longer want to appeal. If your client does want to appeal, you have to get your client's signature on the notice of appeal. There's no exception for that, even if you can't find your client. So if you think your client wants to appeal, it's good to plan ahead, maybe get their signature in advance if you're anticipating an adverse ruling, so that you can just get that done in case you can't find them later. I've had that happen before, and it's no fun when you can't find your client and you know that they wanted to appeal. Okay, so that was a lot, and I'm sorry I had to run through it pretty quickly at the end there. That's my contact information. If you want a copy of the PowerPoint, I think Christy can make that available to you, and I certainly can too. Or if you wanted to contact me by phone, that's my phone number there. And Christy, I don't know if we had any questions that came up or anything else.
I don't see any question at this time, but if you want to ask a question at this time, you can type in the chat box your questions at this time, and I will be emailing out tomorrow a copy of the PowerPoint to everyone, so that way they'll have it.
Great. Thank you, Christy.
You're welcome. Okay, I'm not seeing any questions.
Okay. Well, like I said, feel free to contact me. I'm by no means the expert, but I like talking this stuff through and thinking about it. So if stuff is coming up that's interesting to you, or if you heard anything today that you have questions about or doesn't make sense, or you think about very differently than I do, please don't hesitate to let me know.
Thank you. I'd like to thank Rachel today for doing the presentation. And I'm going to remind everybody of the activity ID number for today's presentation. It is 150682. That number again is 150682. Also, if you ever have any webinars you would like us to do a specific topic, please email those topics to me, and we're always willing to provide those webinars to you. My email address is ccronin@iowabar.org, and I will be mailing out a copy of Rachel's PowerPoint to everyone tomorrow and also with the activity ID number just for everybody's purpose to have that on file. Rachel, thank you, and you now may exit the webinar.
Thanks, Christy. Thanks, everyone. Appreciate it.